Okay, welcome everybody. Let me begin by acknowledging that we meet on the land of the Wurundjeri peoples of the Kulin Nations, and we pay our respects to elders past, present and emerging, recognising that knowledge from the indigenous peoples of this land is present everywhere, and that increasingly I think lawyers at this law school are recognising its relevance and importance. And I see this book launch as an example of that. So thank you very much to Anna Arstein-Kerslake for kicking us off. My name is Margaret Young. I'm Director of our Institute for International Law and the Humanities, ILA, here at the Melbourne Law School. I'm also a professor here at the law school and currently an Australian Research Council Future Fellow on the topic of international law and the blue economy. And within those studies, I've increasingly recognised discussions about legal personhood of entities that traditionally Western law has not considered as befitting that status. So questions, including by the panelists today, have been posed and are continuing to be animated. So we have a great lineup of speakers in an informal conversational format, as we hope for this book launch. And I'm going to introduce each of them now. We're going to have about 40 minutes of discussion from our speakers, and then we've left some time for a Q&A with the audience. All of this is being recorded for our ILA podcast and for the visuals. So if you're not happy with that, please come and see me after. We can do edits and things if need be. But for the moment, I'm very pleased to be able to record this for posterity for ILA, as well as to experience this face-to-face presence. Okay, so I'm very, very pleased to welcome Associate Professor Anna Arstein-Kerslake and to congratulate her on her latest book. You will know her as Director Student Experience here at Melbourne Law School. She's been the academic convener of the Hallmark Disability Research Initiative. That was from 2015 to 2019. And she's founded and directed 2 disability clinics here at the law school. I'm delighted to announce that she'll be leading a reading group for ILA in semester 2. We also are joined by Professor Helene Lambert, who is our director of the Melbourne Law School's Peter McMullen Centre on Statelessness. She joined us recently, actually, December 2024, from the UTS in Sydney, but she's worked in a variety of Australian, British and European academic and policy settings, including with the UN Refugee Agency, the UNHCR, and the European Commission. So in a moment, I'm going to invite Helene to give some comments on the relevance of this new book, particularly in her research agenda. We're then going to hear from Anna herself, who will provide some background to the development of this text and her hopes for the book for the future. And then we've set aside 2 sort of blocks of conversation, first with Dr. Erin O'Donnell and Anna. Many of you will know Erin, who is Senior Lecturer and ARC Research Fellow here at the law school and an expert in water law and policy. She's been recognised internationally for her research into the groundbreaking new field of legal rights for rivers. The next block of conversation will be between Anna and Associate Professor Olivia Barr, who is the author of A Jurisprudence of Movement, Common Law Walking Unsettling Place. That was from Routledge in 2016. She, among other things, is contributing currently to a teaching program on law reform here at the Melbourne Law School. She's previously worked as a government solicitor in law reform and for the UN Permanent Forum on Indigenous Issues. So with those introductions, please let me hand over to Helene, who'll come to the floor and provide some comments. Thank you, Helene.
Thank you, Margaret. And thank you, Anna, for the opportunity to speak. I'll be very brief, only a few minutes, but about the importance of the book to the issue of statelessness. To be stateless means not being recognized as a national by any state. And the lives of stateless people often involve struggles to access basic rights which anyone with a nationality take for granted. So stateless persons, but also refugees, and some of whom are stateless, are obvious examples of marginalised groups. And the starting point of Anna's book is the concept of legal personhood, as we've just heard, and the reality that historically marginalised groups have often been excluded from legal personhood, which is in the book broadly equated to legal capacity. However, when it comes to stateless persons and refugees, things are a little bit more complicated. Because unlike other categories of people, these two groups were found to deserve special protection following the Second World War. Indeed, shortly after the war, the newly formed UN organizations had to respond to the massive displacement of refugees who had been denationalized and had therefore become stateless. And the nation state, which is at the core of Anna's book, the nation state was placed at the center of this new world order. And with it, a concept of human rights that elevated nationality as the principal mechanism of protection. And when the 1948 Universal Declaration of Human Rights was adopted, it proclaimed that everyone has the right to a nationality. Those who were not recognized a nationality by any state found themselves effectively without a capacity to exercise their human rights. And so the 1951 Convention relating to the status of refugees and the 1954 Convention relating to the status of stateless persons were adopted as a way to resolve this serious anomaly. To be sure, both conventions, the Refugee Convention and the Stateless Persons Convention, provide that even in the absence of a nationality, these two categories of people were provided a legal status, and they were guaranteed a minimum set of rights under the operation of international law, and that's important. And these rights included the right to access to court, education, employment, etc. But of course, the reality, which is reflected in one of Anna's chapters, is that the Refugee Convention has been well implemented and ratified and implementing domestic law of the state parties, but the Stateless Persons Convention has not had the same success, and primarily because states still see nationality as a feature of their sovereignty. And this thinking is reflected in Anna's chapter 5. The chapter is on legal personhood, migrant groups, and stateless peoples. And it contends that statelessness largely equates to a lack of legal personhood. Stateless persons who do not possess an immigration status of any state are broadly excluded from international human rights law, and they are not recognized as falling within the jurisdiction of any state. And as such, she argues, quite rightly, that stateless persons are perhaps the epitome, and I quote here, the epitome of why the right to legal personhood is so important, and why we must uncover a method for realizing the right to legal personhood for all peoples, including realizing it over claims of state sovereignty. And the chapter then importantly identifies the impact of a lack of legal personhood, including compounding poverty resulting from barriers to employment, barriers to education, to the right to family life, property ownership, indefinite detention, also the barriers faced by stateless communities in accessing courts, realizing their legal standing and enforcing their rights. In other words, all the rights that had been acknowledged as missing for stateless persons post-Second World War. And these challenges, in turn, risk perpetuating statelessness, as well as fundamentally undermining the rights of stateless persons. And so Anna's book addresses issues at the core of the experience of stateless persons. And it stands, in my view, as a crucial intervention for how to do better in recognizing and protecting the legal rights of the most vulnerable persons. So thank you for the opportunity, Anna, and congratulations on your book. Thank you.
Thank you so much, Elaine and Margaret, and thanks everyone for being there today. It's lovely to be able to do this book launch. The book was published in August last year, but I was overseas at the time, and I did a couple events related to the book overseas, one in Ireland, two in California at Berkeley and Stanford, and one at the University of Denver. But I thought it was really important to sort of bring it home here at the University of Melbourne, at Melbourne Law School, and have an event related to the book here. And I think it's so much more interesting to have an in-discussion event with others than to just listen to me talk about my amazing work, you know? Yeah, thank you again for being here. And I thought I would just cover really briefly how I arrived at the research for this book and what my aims are for the book, and then just go ahead and go into the conversations that we had planned with Erin and Olivia. So the origins of the book really are that I started researching the right to legal personhood in the disability space about 15 years ago. And that was because I saw, and others saw, so many violations of the right to legal personhood, which includes agency and standing. So the lack of the recognition of disabled people as rights holders, and the many both formal legal barriers and informal barriers to decision-making rights for disabled people. But as I was doing that work, and my first book is related to that, the right to legal personhood and disability, I realized how much more far-reaching the right to legal personhood is, and denials of the right to legal personhood is, beyond the disability space. So the second book I wrote was looking at disability and gender. So disabled women and gender diverse people, and the right to legal personhood. And then as I was writing that book, I realized that this theory, the theory that we all have a right to legal personhood, applies to all groups, and especially all marginalized groups. And that there's so many marginalized groups that aren't enjoying the right to legal personhood, and I feel like we're not paying enough attention. So what I hope this book does is begin to open up conversation around how we can apply the right to legal personhood across many different marginalized groups. And I think it could also be a really interesting alternative to the right to non-discrimination or the right to equal protection of the law. Throughout my career, and even as a student, I was always disappointed with non-discrimination law. It just almost never does what we want it to do, essentially. And even when we have some marginal success in achieving the right to non-discrimination, it feels like it only gets so far in terms of wider justice goals. And as I was doing this research around the right to equal recognition, the right to legal personhood, I started to see that perhaps we have a right that comes before the right to legal protection, to equal protection. And perhaps that right is the right to equal recognition. And maybe that can give us another avenue for achieving justice goals, and perhaps an avenue that maybe could give us something at least different from the right to equal protection of the law, which has been so disappointing in so many ways. It's still important. I still support non-discrimination law. But I think that we need more justice tools. And I started to see how the right to equal recognition, the right to legal personhood could be a justice tool that could achieve some of those gaps that are left behind by the right to equal recognition. So I hope that is what this could maybe be, or at least start a conversation in that space. And I really welcome any engagement with the book, but in particular the discussion that we're going to have here today. So thank you so much.
Thank you. I always like hearing about the process behind a book, so thank you very much, Anna, and to think too about the previous books and how they link with this one. It's really fascinating. I guess it's a chicken and an egg question. What came first, the lack of legal personhood or the marginalisation?
Right.
Yeah, I'm sure. It's something you've dwelt on. Well, let's kick off our first block conversation, and this one is between Erin and Anna. Go ahead.
Awesome. So it's an absolute pleasure to be here with you all. It's a pleasure to be here with Anna to celebrate her latest book. She and I have been collaborating, as I'll sort of explain in a second, and I find Anna's work a really profoundly important contribution, particularly in the rights of nature conversation. This is one of the most rapidly growing fields of legal reform in the world right now. And one of the questions that bedevils people constantly is, well, what do we mean by legal personhood? And so Anna's work in articulating what that actually means and how to give effect to it and who is obliged to give effect to it is a really important contribution to that conversation. So I'm going to come into a kind of conversation around Anna's book through this lens of rights of nature, which is obviously, it's not a marginalised group that you're talking about in this book, but I think the application of Anna's work to rights of nature is really important. It is a profound tool and strong foundation on which rights of nature can actually continue. So to begin then with one of my favourite quotes from Anna's book from chapter 1. Legal personhood and moral personhood intersect or are related to each other in that legal mechanisms granting or denying legal personhood often do so in a manner that aligns quite closely with theories of moral personhood. And the reason why I would like to start there is because conversations around who deserves legal personhood are often mired in this morality question. Who do we believe deserves it? Who should have it? What should the law be doing in this context? And what is a legal person is seen through the lens of that normative construction of who we think should have it. And there's been books and books of legal personhood theory that elide that connection that Anna articulates so clearly in this book. That merely because we've had this relationship between legal and moral personhood, it doesn't necessarily mean that they're the same thing, and that in fact acknowledging that relationship is really important to understanding and perhaps untangling that connection, which is foundational when it comes to rights of nature. So you've articulated the source of that confusion beautifully, and you've also established a really robust line of evidence from human rights law, starting with the United Nations Declaration, and moving through that through CEDAW and the CRPD. And I think that one in particular from 2012 this is where our work most closely intersects around the obligation of states to empower people to fully enable legal personhood, which that is a little bit of a flip, right? That starts to be a positive obligation. So my question, which I'm getting to, is it possible, do you think, to use this definition of legal personhood developed within the human rights law framing to extend to the wider human community?
Yeah, thanks, Erin. And I'm just finishing citations on the book chapter for your edited collection where I'm answering that exact question. So it's particularly on my mind right now too, because I think in a way this is exactly how I hope the book to be used. So that the definition that I've articulated of the right to legal personhood can be like picked up and applied in various different contexts, including in the context of non-human entities, because that's a real question and it's not a new question at all. I feel like because of the emergence of AI, we're sort of thinking as if personhood in a non-human context is like a new question. It's not at all. We've recognized corporations as persons for a long time, and more we're understanding the thing that many indigenous cultures have understood for a very long time, that natural entities should probably have some kind of recognition as legal persons as well, and where that line sits and what those boundaries are, I think is the interesting aspect, and what exactly as you've said, what the most recent emanation of the right to legal personhood in the Disability Convention gives us, I think, is a quite groundbreaking understanding of legal personhood that moves beyond the sort of Western liberal ideal of a legal person, which is really like a white, able-bodied, cisgender man that has a whole bunch of actually people doing things for him in the background, who's just like making decisions on his own in whatever way he wants to in order to achieve whatever he thinks the good life is. That's where a lot of our legal theory lies in terms of what is personhood and what is legal personhood. So moral and legal personhood, which is of course problematic as it is in any space. And I think it's why also we've arrived at this place where personhood is denied to so many groups that don't look like that original group. White, Western, able-bodied, cisgender men. Basically, if you don't fit that, you're probably gonna have problems with legal personhood because that's how our system is constructed. So what the Disability Convention has done is made a state obligation to provide access to support for the exercise of legal capacity. Now, when they did this, I think this was I know because I know the people that were sitting there doing the negotiation. I was a little law student in New York at the time, and I was like interacting with them as much as I could without having actual access to the rooms where the negotiations were happening. And what they were really seeing is how disabled people in many contexts need support to exercise legal capacity. Sometimes that support just looks like taking down barriers. So not like taking down stigma related to decision-making skills. Sometimes that actually looks like someone with them helping them understand whatever the relevant information is. And sometimes in the context of someone in a coma, for example, or someone who can't communicate, it might look like another person interpreting the will and preference of the original person in order to exercise legal capacity in that way. So there's a whole bunch of work I've done and other people have done to sort of really tease out what that means. But what it means, I think, from a theoretical perspective and from the perspective that you phrased, Erin, around how would we apply this definition of legal personhood beyond humans, is that for the first time, definitely for the first time in an international legal instrument, but I'd say for one of the first times in any legal instruments, we've seen a really clear expansion of what legal personhood means to include our relational environment and how we actually interact with the environment. Most of us aren't able-bodied, white, cisgender men that have a whole bunch of people doing stuff for us in the background and then just engaging with the world and making decisions autonomously. Instead, most of us, even white men, actually engage in collaborative, relational processes when we make legal decisions and when we exercise our legal personhood. So how does this relate to non-human entities? Well, most non-human entities are going to need that kind of support or representation in order to exercise legal personhood. And I think what we have in this definition of legal personhood that has evolved through human rights law is finally a version of black letter law that allows us to expand how we understand legal personhood, to better incorporate the needs of marginalized groups, but also potentially non-human entities. And of course, like we've we've already seen that in so many different contexts. I mean, throughout history, in the way indigenous cultures interact with natural entities, for example, and give voice to the personhood of those entities, but also how we're seeing in courtrooms, especially in the last 20 years, I'd say, recognition of the rights of rivers, for example, in terms of them having standing as and rights, and of course not being able to exercise that in a courtroom or anywhere in the way we would have traditionally understood personhood to be exercised, especially in this sort of liberal construction of legal personhood, which is where the origins of our legal personhood lie. You know, especially in the context of this like white, able-bodied, cisgender man who is like, you know, doing whatever he wants to do to achieve the good life. That's definitely not what it looks like when we ascribe legal personhood to a river. The river is not, expounding or mansplaining anything about what their needs are or how they think the world should work. So I think that relational aspect of legal personhood that I highlight in the book and then apply to marginalized groups, I think it's a really important evolution of the right. And I think the next step is doing this analysis. And hopefully the book chapter that I'm almost finished with will start that conversation of doing this analysis in a more expansive way, and in a way that allows us to sort of solidify what legal personhood means broadly in our socio-legal systems.
That was awesome. Do I have time for one short follow-up?
If it's really short.
Sorry. Maybe something you want to pick up in the next conversation as well. But I just wanted to, I guess, highlight the power of your argument around state sovereignty and whether state sovereignty should be subordinate to some of these rights to legal capacity and to legal personhood, which is particularly relevant to rights of nature when we're talking about transboundary rivers, for instance. So, I'd love to hear you talk a little bit more about that subordination argument that you're making. But maybe Olivia's going to bring that up anyway.
It's a nice segue, and I'm planning a segue. I do want to ask a question about sovereignty. So before I get there, let me just say thank you, Anna, for asking me to comment and be in conversation with you. It's an absolute pleasure to read, and congratulations on your book. The questions I have for you are coming from my current research. One of my current research projects is looking at post-referendum possibilities before the High Court, with the idea that as political options are kind of shutting down, although obviously not in Victoria, we've got Treaty Victoria on foot, that it's worth exploring some common law possibilities. So I'm coming at this as a common lawyer rather than an international lawyer, but I think that the issues are quite interesting. So I really enjoyed the way, and as you just explained, the way you break personhood down in ways I haven't really thought about it so much, because so not just the sort of status of the person, but also standing and agency. And then in the chapter that I read, which looks at legal personhood, racial minorities and indigenous peoples, Anna uses a bunch of really interesting examples to kind of illustrate the sort of various ways in which legal personhood is hard to ascertain. So from kind of, I guess, more obvious historical examples like slavery, where personhood has been denied, to things like being unfit to plead, and sort of which this particularly hits various groups. Denial of parental rights, which you can think about in Australia in terms of the stolen generation, and ongoing prejudice and discrimination, increased incarceration, which limits sort of prisoners' rights to vote or to contract, all these sort of stemming from personhood. Whereas I would have come before reading that, would have kind of thought along the lines of maybe slavery, or maybe again in Australia the sort of the positioning of Aboriginal people as flora and fauna, or the 1967 inclusion of being counted in the census. So those sort of more kind of status level. But I think there's something that's really interesting comes about when you join status to standing, to agency, and you can see the sort of deep patterns of the sort of the promise of personhood and what comes with the denial or the limitation of that. Anyway, with that as context, I just wanted to ask you, I guess, about, I'll get to the sovereignty question, but it kind of links into that is the relationship between individual and collective rights, particularly in the context of Indigenous peoples. So part of your argument is that the individual rights, in particular the individual right to personhood, should be prioritised over state sovereignty. But in the context of Indigenous peoples and battles in different forums, so things like land justice in Australia and native title being conceived as a collective rather than individual right, or intellectual property rights where sometimes knowledge is held communally rather than individually, and kind of that bumping up or that tension that arises that you already mentioned, where if there's a premise of, the individual musician creating a song, and then there's legal protections in IP around that doesn't necessarily isn't necessarily suitable for communal knowledge around songs or medicine or whatever that might be. And so often the debate is a collective versus individual rights, but then I was wondering how you reconcile the often collective nature of those types of rights with the individualized right of personhood.
Yeah, thanks. That's a great question, and I think it's a really important question because, especially in the context, I think, of First Nations communities and Indigenous communities around the world, because it's another really good example of sort of like legal imperialism. So, like one thing that you have to sort of submit to with a human rights framework or a rights framework in general is that it is, to some degree, implementing a Western liberal framework. And that's absolutely happening. And I think there's really valuable critiques to doing that. And my reason for pursuing analysis in a rights framework is basically that there's just still so much power in that framework, and that's, I think, right now the rights framework has to be one of the justice tools that we use because it's just so powerful in our legal systems that are still, not everywhere in the world, but in many jurisdictions, Australia being one of them, and many wealthy jurisdictions, we still are dominated by Western liberal legal and political traditions. So that's kind of like one thing, but then taking the right to legal personhood, expanding it in this relational way is one thing, and I think we do add some more nuance to it in that sense, and I think we're pushing back against its sort of like the traditional Western liberal notions of what a legal person is, but to then place that in especially I think the First Nations context and the Indigenous people, it's not going to fit perfectly because those legal traditions, many of them, have a really different understanding of legal entities. And I'm not going to pretend at all to be an Indigenous legal scholar. I'm not. The only thing I understand is that this liberal political notion of what a legal person is and what a right is a liberal political notion. And it doesn't necessarily fit neatly into what are usually much older Indigenous legal traditions. And yet, like I mentioned, there's so much power that still exists in that recognition as a legal person within the Western liberal tradition. So I think that like acknowledging the tension is perhaps the most important thing to do, and acknowledging the power within still the right to legal personhood, and continuing to pursue this expansive idea of personhood as relational. And I think that's both, like, it's both something we should pursue in terms of like how we exercise personhood, which we discussed with Erin, but also in how a right to legal personhood might look like if it were a group right as well. And I think then you can get some really interesting parallels with the right to self-determination. And that has arisen a lot in the context of First Nations people. peoples, and I think that there's so many parallels there in terms of what that right looks like as a group right, and what the right to legal personhood looks like as an individual right. That I think there's important work to be done there to sort of move those things forward in dialogue. Does that answer?
It does, and I have one more. It leads me to I guess, I just want to ask a little bit more about, I guess, potential risks in that setup. So part of the example when you're using racial minorities and indigenous people is you look also at the differentiation between states that formally recognise indigenous sovereignty and those that don't. And you notice some of the differences that enable for personhood, so there's a little more control in some, but also kind of draw some connections where you're like, actually, even if sovereign recognition occurs, there's still some major barriers to legal personhood. And so I'm just wondering, and then you sort of offer kind of some beginnings of a conversation of how to kind of, I guess, better navigate some of these barriers. And so in terms of the danger of further marginalisation, I guess I'm wondering about the risk of further colonial imperial imposition of, as you said, Western liberal concepts of the person, of rights and so on, being inserted in. So while I recognise the power of the time and the language and the sort of strategic, tactical desire to perhaps participate, if those concepts don't mirror well with the sovereign expression of another nation's law, what are the risks of not that state sovereignty owes on but what's the risk of turning attention away from state sovereignty to the individual right of personhood for those communities that are already marginalised?
Yeah, I think there's a real risk, and I think that it can't be ignored. And I think that actually is a risk also for women that don't fit into the traditional liberal understanding of what a person is, which is how our legal system is constructed. For example, women, but all marginalized groups. I think because we're taking what has been an oppressive understanding of legal personhood and trying to create a right out of it and then apply it across oppressed groups, I think it's inherently not going to fit perfectly. And I think if I was the queen of the world, which would be lovely and horrible at the same time, I would completely deconstruct the whole system and try to have something new that wasn't that was more reflective of the reality of how all of us live our lives and interact with people and make decisions and interact with our state systems and all this kind of thing. Unfortunately, I'm not the queen of the world, I would love to do that, like thinking at some point if anybody would publish that of like what the legal system should look like if we weren't like dealing with what we've got. But I think the reality is we are dealing with what we've got, and I think pushing the boundaries of legal personhood and trying to support that evolution of legal personhood in a way that better reflects women and what women's needs are, and gender diverse people and what their needs are and how they interact with the world, and First Nations and how they interact with the world, and on top of that, the oppression that's occurred for all those groups in the systems that exist as they are. In a way, I think that's sort of, unfortunately, the best way forward in terms of achieving as many justice goals as we can in the immediate, with the acknowledgement that it's absolutely not going to be perfect. And I think you can't avoid some marginalization that's going to occur because we're taking an oppressive concept and trying to transform it into something that's a social justice tool. It's inherently a problem, and I think that like if we tried to pretend it wasn't, we would be in even more danger of creating more oppression.
Well, thank you you very much. Time is upon us, so we have to close. But let me please thank our panellists for their very engaging questions, to our author, and thank you, Anna, for bringing this book to Melbourne Law School, and congratulations from Illa and the rest of us. Thanks.